So the first method of transferring your house to your children is one of the most obvious. It's going to be just placing your children on your deed that you currently have with their original names on it. Now, this is a positive thing because you, number one, have done it during your lifetime, so you know that it's done. Number two, it's relatively inexpensive to do. It's something that you just need to pay recording fees and then the cost of preparation of the deed. And number three, it's going to be public, so your children are all going to know who gets the house. It's going to be whoever's on the deed is going to be theirs. They're going to see it. It's going to be there right now. Now, the downsides to doing this are very significant. So you want to make sure that if this is the method that you choose to go with, that you are very cautious about when to use this. The downside, first of all, is that now you have another title owner on your deed. What that means is that if anything bad happens to your child, not through any fault of their own, just anything negative, they could get into a car accident, they could get into a divorce, they could get sued for any reason, your house is now considered one of their assets that can absolutely be attacked in the event that bad luck happens. Now, number two is going to be that since they are current title owners, they are equally responsible for all of the expenses that you are. Now, it could be that you live in the house, and so it's something that's not a big deal. You're the one that's going to pay the maintenance and the taxes. But if not, if you get sued or you miss a mortgage payment, anything like that, well, you can't really add them to the deed unless you have permission of your lender. So if you have a mortgage, this really isn't an option for you because your lender needs to approve them being on the title as well as you being on the loan. So if you miss a tax payment, they're going to find out about it. They're going to get the letters. Now, one of the final reasons that you don't really want to do this is that you are getting, when someone dies, you get a stepped up basis. A stepped up basis is the market value of the property at the time the individual died. We'll actually sit as estate attorneys and we'll get appraisals done on properties that as of the date of death of the individual who died so that we know what the value was on the day that they passed that was given to the children, so that way the children have that basis in the property. If you gift your children an outright deed or add them to the deed with you when you're still alive, they inherit your basis because it's a gift. So if this is a new property and you just bought it and it's fairly close to fair market value, not such a big problem. But if this is a property you've held for over 40 years, this is something that you bought for a deal and now it's gone up in market value, they're only going to have, for tax purposes, the basis you've put into the property. They won't have any stepped up basis. So again, it's a fairly simple way to accomplish the task. You'll know that it's accomplished. It'll be done during your lifetime. You're going to see that it actually has happened, which is a good thing. However, there's a lot of negatives that come with this deed. Anything bad happens to your child, you could lose your home. So use this sparingly. The next way that you can transfer your home to your children is through a life estate deed. Now, a life estate deed is what happens when we take ownership and divide it by time. So that means that when you are in a life estate or you own a life estate, you own the property for as many days that you are alive. But the minute you expire, your remainder man, the second person on the deed, takes over automatically by operation of law. When you have this type of deed, it's a great thing because, again, it's done during your lifetime. The child who's on the deed has given their permission to record it so they know it's coming and they can expect it. But unlike a original adding the child to your deed, your child does not have any rights to your property or physical rights to occupy or use your property until after you die. The bad side to this is that this can go sideways so many ways. If you add more than one or two children to the deed, let's say you add 3 or 4, when you die, the second you die, those 4 children are all going to be together on the deed at the same time. Now, for some families, that's fine. For other families, if you have one bad actor or one apple that may be an addict or not be the most responsible, doesn't always reply to any of your emails or any of your notes or your texts, then what you've done is you've just made the 4 of them co-title owners, and they may not be able to agree on what to do with the land. The other thing that happens, this deed used to be very popular for blended families, right? If it's my second spouse, then I'm going to give them rights to live in the property for as long as they can, and then as soon as they die, my children get the property, and that's a way that I can tie up the deed so that my spouse doesn't give my house away to something else, or my children don't kick my spouse out. Now, that can go sideways in so many ways. The main one is that the spouse, who is not going to have any rights to the property when they die, have absolutely no incentive to maintain it. They have no incentive to pay taxes on it. They have no incentive to repair the roof or take care of that leaky faucet. All of those things that you need to do as a homeowner, there's no incentive for them to do it, because they shouldn't, if they put their money in it, they won't see their money back. That money's not going to go to their children. It's not going to go to their pocket. It's going to go directly into the pocket of who you've decided are the remainder people, your children, on this type of deed. And we've seen this go badly a lot. So you want to make sure that when you're using this type of deed, this is something where you have a really good handle. You only have a couple of remainder men. You know that they're going to get along, or that they have the joint interest in the house. I would never put two people on a deed if one wants to keep it and one wants to sell it, because that's prime for them to argue and fight. You want to make sure that you've got who needs to be on the deed, and who doesn't. If they don't want to keep the property, don't put them on the deed. Give them something else. Make it something different. Because having two people that own property together that don't get along, that don't want to share expenses, and that don't have a joint vision for the property is a really bad thing. In July, New York is acknowledging a new type of deed that is a spin-off of a life use. So another negative thing for the life use is that because once you've done it, you've recorded it, the children are immediately on the deed, they have a vested interest in the property. The negative side to that is that if you ever change your mind, they have to agree with you. If you decide you want to sell the property, they have to agree with you. They have to sign the deed and do all of the paperwork with you, and they could potentially have rights to the profits you get for selling your own house just because you added them in this type of deed, because they do have a vested interest. And for them to sign on the deed and get rid of it is really bad. Like, it's something that you may have to convince them and pay them off to get them off the deed. Now, there's a new type of deed in New York State that takes effect in the middle of July, and it's something that we have not done in this state before, but has been done in many other states in the union, and that is called a transfer on death deed. When you do a transfer on death deed, it's a revocable deed, meaning you create the deed that when I die, this property goes to my next of kin, whoever the children are, and then you file it with your county clerk. Now, that deed does not take effect and is not permanent or permanently recorded until after you die. So you can actually go back to the county clerk and change this deed as many times as you want. So it's a wonderful thing to do if you're like, hey, this is just an emergency plan. If something happens to me, I want this property to avoid probate. So I'm going to put the kids on a TOD, on a transfer on death deed. I'll put a transfer on death deed in the county clerk. It's relatively inexpensive. It's pretty quick to do. And if you decide to change your mind, you decide you're going to sell the property, you decide you don't want to give it to that child, any other reason besides you dying happens, then you can just withdraw the deed. No harm, no foul. So it's a really interesting thing to be able to transfer. The negative side to that is that you have no control once you transfer it that way. They're outright owners of the property if you should die. We aren't sure yet how much the county clerk is going to charge us for recording it. And we aren't really certain, because most recordings, which it shouldn't be recorded or take effect until after you die, but since it's brand new, we don't know a lot of the procedures surrounding it. When it comes in July, then I'll do an update video all about those types of deeds, because they are a very interesting option for a moderate family. If you want to do this, and you can't do this if your child is a minor. So if you still have young children, this is not an appropriate way to give them a property and to avoid probate. But it is an interesting thing. So if you're an older adult, you've got adult children, you only have one or two children, you don't want to spend a lot of money on a trust, you don't have a lot of need for that right now, then it's going to be a great opportunity for you to get estate planning done. Now, the final thing that you can do to get your property to your children in a way that you can manage, if your children are minors, it's acceptable. If you have a mortgage, you can absolutely do this, is to put your property into a revocable trust. A revocable trust is a type of trust that you can alter and amend throughout your lifetime. It's a really good option for young 40-somethings that just have their first house. They may upgrade to another house, but they have minor children or they have young children, and you want this trust to be able to grow with you. Basically, what makes a trust revocable is that you keep ownership and title to all of your property and no one else is involved. So what that means is that you are the grantor, the person who creates the trust. You are also within the trust document, the trustee, the person who administers the trust. And you are the beneficiary. So you are the person that actually receives the benefit of the trust. We put in successor trustees, so you know who'll be managing your affairs if you pass away. We add in different powers for children, so we make sure that there's going to be paragraphs on how to hold the property in trust if you have minor children and something happens to you. But at the end of the day, this particular trust operates very similar to a handbag. So you open your handbag, you put a bunch of property in. You put in your real property, you can put in some bank accounts, you can put in your investment accounts. All of that gets taxed to you. All of that is yours. And it's all the same income. It doesn't need another, type of return. And then it's because it all comes onto your income. It all goes through you, so you don't need another tax return. And then when you die, your handbag just hands over to the next successor trustee. So it's a really simple way to move all your items if you are if you happen to die. Now, I really like these because they're very flexible and we get to write them in a number of ways. And some of the cool things that I can do is make sure that we can add in all of the elements of the prior things we talked about. Life use, if you have a spouse that you want to make sure it keeps the property, it's all you can put in life use. If you want to make sure multiple children inherit the property and that each of them are offered the opportunity to buy it at a reduced rate, we can add in those things. We can put in, if not this adult, then we want these minor children and it should be held in trust for minor children, or it should be sold and used for their college benefit. So we can give some very specific instructions. We can also give instructions on what kind of expenses it can go to pay for. So I've had some clients that say, you know what, I'm happy to fund my kid's school, but I'm not going to fund my kid's wedding. Or I would rather fund a house down payment. I'm not going to fund their honeymoon or their vacation. And those things are really important. If that's where you want your money to go, it's all yours. And at the end of the day, everything inside the bag is yours. So if you have that house that you wrote into the trust at the time that you die, great, everything goes the way you said. But if you don't, then great, that gift just lapses and whatever else you've replaced it with can go in there. You can alter and amend this type of trust. So even if you change states, you can bring it with you. You can change the situs of the trust so that it actually will conform to whichever state you would like it to live in. It's a really unique it's not terribly unique because a lot of people have these, but it's a very effective way for a young individual who's in their wealth building phase to be able to protect their assets from probate, but still have complete ownership and freedom over them. You're not necessarily worried about being tied up to, trick creditors away from your house, like if you were looking at Medicaid assets with this. So this is something that if you have multiple houses, let's say you have a house in different states, you have a house in New York, but you also have a house in Florida, which is pretty common. If you have multiple houses, then this is going to be the easiest way for you to transfer. And if you ever want to buy or sell those properties, you still keep and maintain all of that discretion and decision making to yourself. You don't need your children to agree or disagree. It's still yours. The downside to a revocable trust is that they're more expensive. And a lot of times people get confused and they think that a revocable trust offers them creditor protection. It does not offer you any creditor protection. Really, all it does is it's a holding cell for your assets so that your assets can pass to the next generation and that you can access and get all of your assets in and out of that bag yourself, in and out of your own handbag. Now, so that means that if you can get access to it, so can anybody else. You end up in a bad accident, too bad. That's going to be something that they have access to all of those items. Those items are yours personally. It is just a fictional title that everything has in. But if the worst should happen to you, it's a very effective way to be able to move your assets, especially if you fit those parameters. So again, if you have a mortgage, a revocable trust is really the only thing you're going to be allowed to do to the deed. It's protected federally by the St. Germain Act. Every other type of deed, you might be able to do a TOD, but that mortgage will have to be paid in full before your actual children take ownership of that property. That will trigger a due on sale clause. In terms of stepped up basis, we talked about that in our original, you don't want to give your kids your deed because they take your basis. You get a stepped up basis at the time someone dies in the last 3 types of deeds we discussed. So your life estate deed, you get a stepped up basis. Your TOD deed, they would get a stepped up basis. And your revocable trust, you also receive a stepped up basis. So all 3 of those would solve that problem as well. Place is pretty spectacular. So I did want to tell you a bit of a story about a life use deed and how it can really screw up your home and your family chain. And I'm going to tell you the story because it comes from my heart. This is one that's from my family. My grandparents, when I was little, my grandmother was very sick and died when I was young, probably about 12 years old. Now, she had inherited a house from her mother in her name alone. So unlike traditional marriages back then, my grandmother owned the house in her own name. Now, my grandmother was a woman of the greatest generation, so we're talking back in the 1930s, 1940s, which is very unusual for a woman in that generation to be able to afford and have her own house. And the reason she had her house in her own name was because her father, my great-grandfather, built that house with his bare hands. And it was right on the ocean, not unlike this gorgeous view we have behind us of the beautiful lake. But it was right on the ocean in Maine. And it was a magnificent spot and a magnificent house. You could actually see where he had hand-hewn all of the beams and boards inside of it. So it was very special. It meant a lot to our family. Now, my grandmother died first, and she left a traditional will. Her will was everything to my husband and then to my son. She only had one son, and that was my father. She had no other children. She had no other living relatives at the time that she died. So my grandfather inherited the house in full and all of my grandmother's assets, and then promptly got remarried. I will say it was probably within 3 months he remarried this new person that we had never met. They were together for about a year before he died. And when he died, he left the house to her in a life estate deed. So she had a life estate of this property that had been in my family now for generations that my great-grandfather had built. And she promptly banned my father and my family from ever returning to the property. Told us that if we ever came on the property, she'd have us arrested. So we did not have access to that land for a lot of years. Now, she was a lot younger than my grandfather. My grandfather was in his late 70s when he died, and this woman was only about 6 or 7 years older than my father. So it was very devastating understanding that we would have to wait until she lived out the rest of her years just to even be able to get on the property again. She died after my father died. So my father died in 2010. And then this lady died in about 2011, 2012. So when she died, my father had never even been able to set foot back on the property that had been his own. When I went to go see the property for the first time since I was 12 years old, I was probably 26, 27 at the time, so about 15 years later, it had been wrecked. Just because she had life use and exclusive use and occupancy, she didn't use it. She was never actually at the house. She got remarried to another gentleman, again, within 3 months of my grandfather dying. So she went to go live with him in his big fancy house somewhere else in the state that they lived in, on Maine, and left our house to rot. Basically, she didn't do any updates, she didn't do any upgrades, and her final 3 years of life, she had found out that she had breast cancer, and so she elected not to pay any taxes or bills on this house that entire time. She also elected not to tell us. And since my father had died, we weren't receiving any of the bills. He only had a vested interest for the life estate, but we didn't get any of the tax bills. We didn't get any of the information. We had no idea. And she dies. We go to see the property. The roof is falling in. The septic is destroyed. All the windows need to be replaced. The whole house smells of mildew and mold because no one had been in it to empty it out. When you have a house on the ocean, that's what happens. And she had left 3 years worth of tax bills plus taxes and fines for not paying them for us to clean up. And it was something at that point in time because my father, who was the main income earner, was no longer with us. And I was still very young in my career. And so was my family. You know, my brother and my mother had not, you know, my mother did not have many assets after my father passed away. She had been figuring out what to do with his things. And my brother and I were both starting off. We were barely making minimum wage and we were just learning what to do with our careers. So we had absolutely no way to save the property. And we ended up having to sell it on a fire sale just to get out from underneath the tax bill. And it was really devastating to have to sell a property that, you know, someone in your family line worked really hard for and on, just because someone else didn't respect the value of that property. You know, if she wasn't living there, she could have gifted it back to us at any time. She just chose not to. So when you do a life estate deed, it may sound like all roses and wonderful things, but honestly, it can be devastating. It can be a nightmare, and you can lose a property that you have worked for really, really hard. And it's not like they're making more coast. So we aren't really, you know, my family at this point, I don't know if we'll ever be able to buy a beach house. I don't know if we'll ever be able to get something right on the water again. For now, I live on a beautiful lake, or, you know, in a village that is on a beautiful lake in upstate New York, and that's about as much water as I would like to see. But it is something that can be pretty devastating to a family if you don't thoroughly explain. So one final story time. When you're looking at a TOD deed and you are deciding whether to add 1 or 3 children to it, then you really want to pay attention. So I had a client who wanted to do a life use deed or a TOD deed to his children, you know, put them right on this title so that he had all 3 of them right there. And he really wanted that because he knew that the kids were all pretty much down on their luck and he didn't want them to have to pay the expensive probate. What actually happened when he died was pretty bad. So when he died, the 3 children, as I mentioned, were all fairly down on their luck. So when they saw that they each were co-owners of a house that did not have a mortgage, they made a decision that that was where they each wanted to live. Now, they did not want to live with each other though. So what started to happen in the family was that these 3 children engaged in absolute warfare to be able to get each one of them off the deed or not have rights to occupy the property. I'm talking about they went and called the police on each other. Some of them showed up, well, one of them showed up consistently drunk at the house trying to break in while another one was staying there. There were orders of protection across the family trying to get each of them to be removed from the deed and from each other. 2 of them ganged up on one of them fought back legally and started suing them. So it turned into absolute chaos where people who really didn't have any reason to argue or fight and didn't have enough assets to argue and fight over just proceeded to engage. So if you have multiple children and any of them are suffering from addiction or are prone to using substances or violence, or if any of them are down on their luck and they don't have a joint interest, meaning that they all want to sell or one wants to stay and they all agree, if they all have a different opinion on what to do with the property, do not put them all on the deed together. You're going to end up just keeping your property in a battlefield for the next few years until they can sort themselves out. And I wish I could tell you how this story ends, but honestly, it's still going on. It has been 6 years and they are still fighting. All 3 of them are still title owners. And at this point, no one's paid the taxes in 2.5 years because no one wants to put money in a property that their siblings are trying to throw them out of. They are just in utter chaos and have been hurting each other. And at the last time I spoke to the children, their entire answer was, well, I'm just going to outlive the rest of them. I will never agree to a sale. So be very, very careful when you do this to your children. Do not assume that how your children behave when you're here during life is how they're going to behave at the time that you die. Understand that they are under grief and stress and pressure that you do not know because they've never faced it before. you're still here. I hope this has given you some valuable information. Have a wonderful day.